Ms Legalista, aka Attorney Sheila here. We're going to be talking about Starbucks refresher drinks. I've never had one of those. Let me know in the comments if you have had one of these drinks. Now, Starbucks has been sued before. I think in the past it had to do with the volume because they were putting a lot of ice in the drink. I don't know. Seems like to me it's very obvious to people when you get a drink that you're not going to get the exact amount because ice is in there. So you could ask them to take the ice out. But in this case, there's something a little different going on. We're talking about these refresher drinks and what they have in them. I think there's some concern that Starbucks maybe has not been upfront with what is actually in the drinks and maybe has been saying that it represents this when in fact here's what's going on. Let's jump right into this if I can actually find it on my computer here because I have so many tabs open. This is coming out of the Southern District of New York. Joan K., the plaintiff, Starbucks Corporation, jury trial demanded. Let's see, summary of the action. This class action seeks to challenge defendants' false and deceptive practices in the marketing and sale of a number of its Starbucks refresher products, which are marketed as fruit-based beverages available for sale at Starbucks brick and mortar locations. Starbucks has marketed the products with the name of specific fruits, representing to its consumers that the products, which are supposed to be fruit-based beverages, contain those advertised fruits. Specifically, the products include the following. Number one, mango dragon fruit lemonade Starbucks refreshers. Number two, mango dragon fruit Starbucks refreshers. Number three, strawberry. I can never remember how you say that name. Acai? I don't know. Lemonade Starbucks refreshers. Four, you've got the same with strawberry. Pineapple is number five. Pineapple Passionfruit lemonade Starbucks refreshers. And six, pineapple Passionfruit Starbucks refreshers together form the products. Despite their names and unbeknownst to consumers, the mango dragon fruit and the mango dragon fruit lemonade refreshers contain no mango. Okay, so that would have caught me off guard because I would have thought that it had mango in it. The pineapple passion fruit and pineapple passion fruit lemonade refreshers contain no passion fruit, and the strawberry acai contain no acai. I guess that's how you say that. Further, all of the products are predominantly made with water, grapefruit juice, and sugar. Okay, so now I might be a little concerned if I'm purchasing this product, and that's really what I'm getting. Plaintiff and other consumers purchased the products and paid a premium price based on their reliance on defendants' naming of the products. Had plaintiff and other consumers been aware that the products are missing one of the named fruits, they would not have purchased the products or would have paid significantly less for them. Accordingly, plaintiff and class members have been injured by defendants' deceptive business practices. Okay, plaintiff is a citizen out of New York. She purchased one of these refreshers at locations in New York. She believed it contained acai. I guess it did not. And of course, she's saying she would not have paid that much for it. Starbucks is the defendant. The jurisdiction and venue, we're going to skip all that. Let's jump right into the factual background here. Defendant, Starbucks, is responsible for the formulation, manufacturing, marketing, naming, advertising, and sale of its beverage products sold in its thousands of retail stores located in the U.S., including the products at issue here. The products are part of defendant's refresher line of beverages, marketed as fruit-based beverages. Unfortunately for consumers, defendant engages in false and misleading advertising regarding the products to gain a competitive edge in the market, all at the expense of unsuspecting consumers. Specifically, and there I scrolled too fast. For each of the products, Starbucks has marketed the products with the name of specific fruits, representing to its consumers that the products, which are supposed to be fruit-based beverages, contain those specific fruits. Indeed, as portrayed below, the presence of fruit in the products is central to the product's identity. So they have included pictures. Make a splash, crafted with refreshing lemonade. Paradise Found, sunny new drinks bursting with pineapple. And then you see the names of the drinks listed below the images. And, you can see in some of these that they actually have pictures here that makes you think, these drinks have fruit in them, or that they're fruit based, as they say they are. And then you've got the Frappuccino. They're listing the tea and refreshment. Okay, now that I think back, I actually have had one of these drinks before. All right, based on the product's advertising, reasonable consumers purchase the products with the expectation that the products contain all the fruits clearly listed in their respective names. I would have thought that. However, unbeknownst to consumers, the mango dragonfruit and mango dragonfruit lemonade refreshers contain no mango. And we've said this before, no passion fruit and no acai. Instead, all the products are predominantly made with primarily comprised of water, grape juice concentrate, and sugar. This is not what consumers expect when it comes to Starbucks items. Consumers expect Starbucks products to live up to their name, and many of them rightfully do. Indeed, Starbucks hot chocolate contains cocoa, its matcha lattes contain matcha, its honey mint tea contains honey and mint, just as consumers expect. While these Starbucks products live up to their names and contain their promised ingredients, the products are missing mango, passion fruit, and acai. Moreover, furthering the deceptive nature of Starbucks advertising is the fact that the products do in fact contain freeze-dried pieces of strawberries, pineapple, and dragon fruit, which would indicate to a reasonable consumer that the product fully lives up to its name by advertising all of the fruits advertised in the product's name. Thus, the product's names are deceptive. Notably, nowhere does Starbucks disclose that these products are missing their promised ingredients. As such, consumers cannot reasonably know or expect that the products are each missing one of the named ingredients. The reasonable belief that the products contain all their advertised fruits was a significant factor in plaintiff and other class members' decisions to purchase the products. These missing fruit juices are important to consumers because they are premium ingredients, and consumers value them over the less nutritious and cheaper grape juice concentrate found in the products. For example, acai berry and its juice, which are missing from the strawberry acai, and I cannot pronounce that for the life of me, are known to provide benefits to heart health, cognitive function, and contain anti-cancerous properties. Mango is also known to be a great source of magnesium and potassium, and passion fruit is known to be rich in vitamin C, vitamin A, fiber, and other nutrients. Conversely, grape juice concentrate is a less premium ingredient commonly used as a cheap filler in juice products. Thus, Starbucks promises premium products but provides consumers with cheaper, less premium alternatives. And I'm going to stop there and make just sort of a note of something. So if you're this person who has decided that you're going to be on a specific type of diet, and that, for instance, you're looking for products that contain magnesium and potassium because you're trying to round out maybe some of what your intake is regarding whatever, and you're saying, hey, I'm going to drink this because this will help fill in some of these gaps I have here. And so now you think that you have your medical and your health sort of diet put together, and nobody's drinking these things every day all the time. But if that's why you're purchasing it, then all of a sudden the whole idea of, hey, this is what I'm having, that just goes out the window because you really aren't getting those products. And I think that's a really big concern here. All right, let's scroll down here. As the entity responsible for the development, naming, manufacturing, advertising, distribution, and sale of the products, defendant knew or should have known that the products falsely and deceptively represent to contain certain ingredients that they do not contain. Defendant also knew or should have known that plaintiff and other consumers in purchasing the products would rely on defendant's advertising. Nonetheless, defendant deceptively advertises the products in order to deceive consumers and gain an unfair advantage in the market. So here they are laying out what they think the motivation is. And really what the translation is there, it's yes, deceive consumers. This is where they're going with this. Deceive consumers, get them to buy it so that we gain an unfair advantage in the market and we make more money and get more people. Consumers are willing to pay more for the products based on the belief that the products contain mango, passionfruit, and acai. Plaintiff and other consumers would have paid significantly less for the products or would not have purchased them at all had they known the truth about them. Thus, through the use of misleading representations, defendant commands a price that plaintiff and the class would not have paid had they been fully informed. Therefore, plaintiff and other consumers purchasing the products have suffered injury, in fact, and lost money as a result of defendants' false and deceptive practices as described herein. And then this next piece gets into how they're saying that they meet the definition of a class and why this should be a class action here. And I'm not really going to read that. You have claims for relief here that they violated New York's general business law. As you see here, it says New York general business law prohibits I cannot talk this morning. Deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service in this state. And of course, they're still talking about the fruit, right? And this other part says, false advertising in the conduct of any business, trade, or commerce, or in the furnishing of any service in this state is hereby declared unlawful. And then you see right here, it says the term false advertising means advertising, including labeling of a commodity or of the kind, character, terms, or conditions of any employment opportunity. And look, it says down here, in determining whether any advertising is misleading, there shall be taken into account, among other things, not only representations made by statement, word, design, device, sound, or any combination thereof, but also the extent to which the advertising fails to reveal facts, material in the light of such representations. So that is exactly what they are claiming. Not only did they put statements out there saying that this is what it was, but they then failed to say, hey, this is what it is not. And so they're arguing both ways on this. Then we have violations of the breach of express warranty statute. Excuse me. Let's see what else we have here. Our fourth claim for enrichment, in the alternative, unjust enrichment. They've been unjustly enriched because they told people that they were selling them something and then they got paid for it, even though that wasn't what it was. Defendant had knowledge of such benefit and obtained the benefit by its misrepresentations because the misrepresentations induced reasonable consumers to purchase the products when they would not otherwise have purchased them or would have purchased them at a lower price. That's the key to that. Then we have the fifth claim for relief, which is breach of implied warranty. And then finally, the prayer for relief, which says here, all right, first of all, let's see, declaring that this action is a proper class action, a declaration or declaratory judgment that defendant's conduct has violated and continues to violate the statutes and laws cited herein. There's New York business laws we went over and some other things. An order requiring imposition of a constructive trust and or disgorgement of defendants' ill-gotten gains and to pay restitution to plaintiff and members of the class to restore all funds acquired by means of any act or practice declared by this court to be unlawful, fraudulent, or unfair business act or practice. Then they also want damages, statutory and punitive damages, distribution of any monies recovered on behalf of the members of the class, an award of recoverable costs and expenses, including reasonable fees for plaintiffs' attorneys, and then also any pre or post judgment interest. So there you have it. Basically, it comes down to the fact, if I can find my tab and open this completely back up, I should not have so many tabs open. This is really like searching for a needle in a haystack. Well, let's get rid of that. And then as it blinks, I can now see, ta-da. All right, so now you understand what is going on with these Starbucks refresher drinks. I have not been into Starbucks lately, and I wonder if you walk in there, if those drinks will still be listed on the board. If anybody has been in there recently and you've seen that those drinks are still up there, let me know. Let me know if the full name and description is still up there. Because if I was Starbucks, you're in a catch-22. If you take it down and reframe it and try to now clean it up, it almost looks like it's an admission that you had done something wrong before. However, if you take affirmative steps to make sure you're now providing the correct information, then you're sort of mitigating some things that you have done wrong. Attorneys will likely tell you not to change anything because it's going to look like an admission of guilt. My personal belief is that you find a way to sort of say, you know what, in an effort to provide you with more information about these products, we're now going to give you all this information about all of our products. Okay, that's a way to do it. And then at that point, people have the information and can make an informed decision, because right now they're in this lawsuit that's saying people do not have the information and that Starbucks did not reveal it to them. So if this gives you some information about drinks the next time you get ready to go into Starbucks, I hope this helps you out. You can give the video a thumbs up. Don't forget to hit the notification bell, and peace. Have a good day.